Hello there, ladies and gentlemen. A very good evening to you. I wonder whether it's evening or morning, but of course, depending on the time and where you're watching us from, a very good day to you, and welcome to another episode of the Candid Talk. Definitely, I'm aware that we're being watched with people across the globe. Welcome to another episode of the Candid Talk here on Herman Manyora's YouTube channel. Such a pleasure to have you always on board. Remember, we're always here to keep you updated with comprehensive analysis of everything that is taking place within this country and abroad. And we do hope that these conversations, which are always very mature, will actually influence the kind of government policies that are being made in this country, because I'm always here with a number of guests who are experts in matters public governance and policy therein. This fine evening, I'm joined by Wakili Willis Otieno once again. How are you, Wakili?
I'm fine, thank you.
You've been part of this family, and I was just going through the comment section, and our audience more than happy to actually have you on board.
Thank you.
And they're here encouraging you and telling you to go ahead. A number of them I saw saying that they'll be there with you in 2027 when
I am Depa.
Are you people serious that in 2027 you must be there on the ballot?
No, the choice is very clear. We have Rigathi Gachagua and Willis Otieno. And you ask our viewers, between Willis Otieno and Rigathi Gachagua, who meets the qualifications to be the deputy president of this republic? Who is the one that you can say you can even leave your household with to take care of? And the choice is unanimous. Everybody who I've met in all public forums I've attended, people have said with unanimity that Willis Otieno, you deserve to be the deputy president of this republic, but not deputy to William Ruto, deputy to Jimmy Wanjigi, who is our party leader. Yes, and the people are seeing it and the people are coming on board. I welcome more of my listeners. Let's engage on the economy. That is what the problem is. And Kenya Kwanza, in my view, has failed to address the economic problems of this country. They have no response. They're only causing us more pain. And the people will decide.
We're waiting to see you there come 2027. As you said, yeah, we hope that this time round at least you people will be cleared to be on the ballot.
We will be there.
You'll be there. Now, I want us to have this conversation. We've had this spat between the executive arm of the government and the judiciary.
Yes.
The president, of course, has sustained his attacks on the executive, and a number of our leaders in this country affiliated to the Kenya Kwanza government, even the deputy president, going as far as mentioning a particular judge and saying that he'll actually lead by example. And of course, right now, is a little bit toned down after the Chief Justice Martha Koome actually extended an olive branch. I wonder whether I should actually call it an olive branch, but whatever it is, and has called for dialogue between the executive arm of the government and the judiciary therein. A number of leaders across the divide, especially those from Azimio, have criticized this call for dialogue. Members of the Law Society of Kenya are saying this is an affront to justice system in the country. I wonder what you make of the kind of decision that the Chief Justice actually made to extend an arm to the president so that these people can actually come on board and talk over these things.
So the first question that you ask is, what the dialogue, what it will be about? Are they going to be discussing ongoing litigation, active cases in court? In what capacity? Will the Chief Justice be inviting a litigant to discuss the conduct of their ongoing case or litigation in court? So it is very wrong in the first place for the Chief Justice to purport to convene a meeting between herself and the executive to discuss issues that are still pending before courts. Because remember, Kenya Kwanza Brigade had specifically said that judges are being bribed to influence cases. So when the Chief Justice is inviting them and it relates to cases which are still active in court, is she now going to be discussing the merits of those cases outside the courtroom? The people of Kenya have already given themselves a dialogue document on how the three organs of government are supposed to relate. And that is found in the Constitution. Any convocation of a dialogue forum to discuss the merits of a case or the particulars of any case that is pending before a judicial officer at any level between the Chief Justice and Ruto will be legal. And we must call them out. You cannot have that kind of a dialogue. There is already a set mechanism through which if any Kenyan has a grievance against a particular judicial officer, they should invoke it. File a petition, write a petition, file it to the Judicial Service Commission, and provide the evidence for that judge to be removed. Gachagua did promise Kenyans last week that on Thursday this week, he will be presenting evidence of corruption against Justice Maina before the Chief Justice. I waited for it until midnight. Nothing was forthcoming. And what I saw was a statement from his office that because of dialogue, he will now not present the petition. So, because of the extended invitation to dialogue, what happens to the reputation of the good judge that he just maligned? Because he said she was corrupted, influenced to make the decision she did. So what happens to her reputation? Does that go just away like that? He must be called to order. You cannot use the stature of a judge to score political points. And that is what Kenya Kwanza was doing. And it's quite unfortunate for Gachagua to pick on the poor lady, Justice Maina, as a punching bag. Anybody who has been before that lady's court will tell you she's a no-nonsense lady. And she's rose through the ranks of the magistracy to become a judge. And she's performed in a stellar way so far. I've never had any complaint. And if there be any complaint against her, there's a procedure that is provided in law that anybody could have used. Now, Gachagua, having used a name to score political points, drops that complaint as if it ever existed. Because I believe it didn't exist. That was just political witch hunt. And we must call it for what it is. Kenya Kwanza is engaging in McCarthyism against judicial officers. They're engaging in mob lynching against judicial officers. And the courts and judicial officers need to stand strong. Us as the public, we shall defend them. But even within themselves, they need to stand strong and firm to fight this onslaught against them. Because without court orders, there's nowhere they will go.
Make me understand this. Where is the deputy president wrong here? Is he wrong in his utterances? Because actually he said that he would be presenting a petition to challenge the conduct of Justice Maina. I want us to make it, is it wrong that he decided not to go ahead with the kind of statement that he made, or was he wrong in making that statement?
He was wrong in number one, thinking that because a judge decided a case against you, that judge should be removed. If that is the principle for the removal of a judge, then we should start from the Supreme Court, the ones who decided in their favor, the last election. Yeah, let all of them go, because the Azimio Group Brigade will be saying, these judges decided a case against us. We are using Gachagua's principle, let all the Supreme Court judges go. We start from that. So that anybody who a court decides a case against, their recourse is to apply for the judge to be removed. It is wrong. That is why we have an appellate process. I cannot seek for the removal of a judicial officer just because a case went against me. And more so, when that case is even pending on appeal. So the case he was talking about, the judge made a ruling based on the evidence before. If he was not satisfied, he appeals. And I think he has appealed. Now, you cannot say because the judge ruled against me, now the judge needs to be removed from being a judicial officer. That's what I'm calling mob lynching. That's a witch hunt. That is not a removal of a judge in the pursuit of the rule of law and democracy. That is attempting to intimidate a judge that next time my case comes before you, please look at me favorably. That is where Deputy Gachagua goes wrong. And we must call him out for it. If he had any evidence, second time, that this judge is corrupt, because of the dialogue, she stopped being corrupt. Right? Then he must present that evidence. He must file that petition as he threatened. That petition that he threatened to file, he must file it. We want to see the substance of that petition. We want to see the evidence that he has. And it will expose him for who he is. He was just abusing his office to intimidate the poor lady. There was never any evidence in the first place against the lady. There was no legal basis to even make those kind of allegations against a person, because these are about reputations. You cannot just go to the public domain with somebody's name and just drag it carelessly. You call them names and you say they've been influenced to decide a case in a particular manner. You know, judges don't have a similar platform where they can respond. If you go to the platform with my name, for example, I'm a politician, my next day will come, I'll have a platform and respond appropriately. But a judge does not have a platform where they can come up and start saying a response to the public. The most they can do is if you take it to JSC, they'll be invited, get the platform to respond to the allegations. Or if you have a case before a judge, you make your case, the other side makes its case. Why was Gachagua complaining about the judge and not the investigator, not the asset recovery agency? The judge didn't file the case before a court. She didn't investigate that case. This case was investigated by the asset recovery agency. That agency has lawyers, senior lawyers even. It has senior investigators, former policemen, and policemen serving. They investigated, formed an opinion. After forming their opinion, they drafted pleadings. They went to court registry, filed those pleadings. That file was taken before the judge. It was served upon Gachagua. He appointed his lawyers. They did a hearing. Asset recovery, their lawyers said what they had to say. Gachagua and his lawyers had what they had to say. The judge was in the middle. She never filed a single document. All the documents that were before her were brought by the parties. She made a ruling in the way she did, in favor of one side. So why don't start, if you think there's a problem, start with the asset recovery agency, the investigators, the lawyers there, the registry even that received the file, filed the case. Then now you can say, okay, I'm coming to the judge. But you see, they single only the judge because it is pure witch hunt. There's nothing about rule of law.
What do you make of Azimio la Umoja, One Kenya Coalition leader Raila Odinga's statement saying that it's like for him, the judiciary wants to go like on a bed with the executive arm of the government, and of course he's saying that we cannot get back there as a country.
Of course, that is also possible, and more so in light of the decision that came out of the Supreme Court yesterday against Herman Manyora, where the court decided through a communique to issue what is termed as a disbarment of Herman Manyora Senior Counsel from being a practitioner in the Supreme Court of Kenya. Not just Herman Manyora, but his entire law firm and all the lawyers who practice in that law firm, by virtue of certain tweets which the courts and its judges find uncomfortable that Herman Manyora purportedly has made. Now, under which law do they get the power to disbar permanently an advocate from appearing before a court?
I want us to get to that conversation.
So, I'm coming to that. I have to explain to you. So, we must look at that statement by Raila against the background of this conduct. And you'll find, even this court, even while we are defending the courts, even them, they are showing us signs of being a dictator. And Ruto is also showing us signs of being a dictator. So, there are two birds, there are two sides of the same coin. They are birds of a feather, they are flocking. So we will fight for judicial independence to defend the institution, but also fight the institution internally to make sure they don't become tyrants.
Okay. Now, make me understand this. Wakili, the president, while speaking, of course, wasn't a political rally. Rather, he had gone to launch some development project in Trans Nzoia County therein. And, of course, while addressing the people therein, actually questioned why Raila would be against the dialogue between the executive arm of the government and the judiciary. While back then when they had that kind of disagreements, Raila called for dialogue and Ruto accepted, and they sat on a table and spoke. We are just here still waiting for the full implementation of the reports of the National Dialogue Committee. So he is actually asking, why is it that this guy really wanted us to talk, but then when we decide to talk now between us, then he sees the problem. Is the president playing politics, or what is it?
It's very simple. Which institution does Raila head in government? None? In the public service? Which institution does Martha Koome head? Judiciary. Established. As relates to Martha Koome and William Ruto, these are institutions established in the public service by law. And the manner in which they're supposed to be interacting or engaging is set out. We even have what is called the National Council on Administration of Justice that brings all the justice sector actors, Chief Justice, Attorney General, Director of Public Prosecutions, the DCI, Inspector General of Police. They're all in that NCAJ. So they already have what could be an in-house mechanism to deal with whatever issues you have. And that JSC is the body with the responsibility to oversee any misconduct by a judicial officer.
Okay.
So what are they going to dialogue? The mandate of the JSC? The mandate of NCAJ? You already have institutions established in government. So there's no dialogue they're doing. That dialogue will only mean one thing, that President Ruto is summoning Martha Koome for a tongue lashing, to have her to cow down to his whims. And because you can notice already, the discomfort that Ruto is facing is from decisions made by the courts. Some of those decisions are still being challenged in the appellate process. Let him go and argue his cases like the rest of us. Even as we go through, we lose cases, we don't summon judicial officers or the head of the judiciary to come and hear corruption. If we feel there's corruption, we go to JSC with our petitions. We submit, wait to be called, and we act upon it. Him even as a representative too. That is two direct appointees. Attorney General is the one who appoints, sits in JSC. You have from Public Service Commission, his nominee sits in JSC. So he has 4 out of 9. 4 that comes from the president. So when he's telling you that there's corruption in the judiciary, of course he's lying. He's not being truthful to Kenyans. Because if there's evidence, he has a platform, he has people. His own people sit in JSC. They are responsible for oversighting the judiciary. If he has evidence, take it there.
And this actually raises a lot of questions now that he is saying, because the government, the president is saying is accepted this kind of dialogue because they want to actually look at everything between what is actually taking place within the government, between all these different arms. We've got the executive, we've got the National Assembly, as well as the executive, to root out what he terms corruption. Do you think that this is the right way to do so?
It cannot be the right way. That's why I've told you. I don't think at any point we've suspended the operations of Ethics and Corruption Commission. I don't think at any point in our history we've suspended the work of the DCI. I don't think at any point we've ever suspended the criminal justice system in this country. And nothing stops the president. You don't need a dialogue to root out corruption. You need agencies to perform their functions. Let the investigative agencies investigate. Let cases be filed. Let those who are corrupt be arraigned in court. Let the evidence be brought out in the public. It is not for them to say that we will not fight corruption because we've not had a dialogue. We've not had a conversation. We've not had a meeting together. It simply means that whatever is trying to create is creating an amorphous process that is trying to circumvent the rule of law. You want to create a new platform, a new sphere of influence, a new sphere through which you will be trying to fight for this so-called corruption. That is what in America they call Machiavellism. Because then it means that this ad hoc body will be the one to decide who is guilty, who is innocent. And they shout at you, then you are condemned and had. Right? That is not what this country is about. This country is about the rule of law. Let us use the instruments and the legal process as established by our constitution and laws to deal with any grievances that we had. Because the last time when we didn't use those instruments or the procedures provided by law, this country almost tore apart. Now the president cannot be the one leading the process. That is why even whatever dialogue is saying, Raila doesn't hold any public office. There is no established institution for Raila. So when they had their dialogue, that's a political dialogue. But whatever they did, they sent it to the formal state structures to consider and take appropriate action. That one is possible.
Okay.
Because one is holding office, one is not holding any office. So there's no established structure. But these ones are two people holding office. And we've established for them mechanisms of engagement. Now, which other dialogue do they want to have?
Okay. During her interview, definitely for the position of the Chief Justice therein, Martha Koome promised that in case such kind of differences would arise between the executive arm of the government and the judiciary, then she would actually extend an olive branch and talk, because it's like her approach is a little bit different to her predecessors, the likes of Chief Justice David Maraga, who would actually call on the excesses of the executive arm of the government at the end of the day. Here we are going by whatever statement you say. She said very well that she would reach out to the president in case these matters arose. Right now, we've seen such happening here in the country. And that's part, of course, is not good for our development as a nation. What is actually wrong with her implementing what she said back then?
She was made a Chief Justice not to implement her own wishes. She was made a Chief Justice of Kenya to be the Chief Justice and conduct herself in the manner prescribed by the Constitution and the law. So despite your personal feelings, once you assume the office of Chief Justice, you must now bow down to the Constitution and the law. There is nowhere in the Constitution and the law that allows the Chief Justice to go and discuss with the President the conduct of judicial proceedings that are pending before any courts. So if the complaint that the President has is in relation to proceedings that are active before any court, aende JSC. And Martha Koome, even as Chief Justice, has no right whatsoever to try to circumvent that legal process established by law to deal with the President's complaint. Even as she's subject to the law. So what is this olive branch you're talking about? The kind of olive branch that I believe you should have meant is if there's administrative hiccups, the executive has delayed in disbursing funds to the judiciary. That's the kind of conversation. The judges need the following cards they're not receiving. We are not getting enough security for judicial officers. That is the kind of thing they can be talking about. But they cannot be having an olive branch and a dialogue over active proceedings and litigations that are going on before various judicial officers across the country. That dialogue will fail. That dialogue has failed and will fail. There is nowhere Martha Koome and William Ruto will go with that kind of a dialogue, because we have what you call decisional independence. Decisional independence of the respective judicial officers with respect to the matter before them. So Martha Koome should not even dare pick a phone call to call a judge, rule in this particular way. That will be interfering. In fact, she will be in contempt of court. And if it happens, it will be a sad day for this country. We will have actually suspended our constitution and the judiciary chapter of it.
In as much as these, the judiciary is independent, of course, the parliament as well as the executive arm of the government, as the law stipulates. Then when such matters arise, how then do we ensure as a country that our arms of the government function properly and in harmony?
That's why I said, your reference is always the law. Because the law has already envisaged that these things will happen. That's why if the executive feels a judge has been bribed, they're in JSC. There is a process provided in the JSC Act for lodging a petition. Just file a petition. Let JSC hear the complaint. Summon the judge. Deal with him. If it's tribunal, tribunal is constituted. You remove the judge. But if you think that process is inconvenient, that you prefer the public platform, that you are doing a baraza and discussing judicial conduct in a baraza, then the problem is you, not our system. The law already envisaged it and provided an avenue of how to deal with those challenges. But it seems Kenya Kwanza prefers doing it from the top of cars, in public barazas in Chwele or Trans Nzoia. That is more effective than going to JSC. And JSC is not far. JSC's offices are just here at the Insurance Plaza. It's barely one street away from Arambe Avenue.
Okay.
Both of them can walk there. They can even walk to submit their petitions. They don't even have to use registered mail if they have a complaint against a judicial officer and they really minded to have it determined.
Well, ladies and gentlemen, that is the conversation that we've been having here with Wakili Willis Otieno. Of course, you can weigh in on this conversation and tell us what you think about the kind of olive branch that the Chief Justice decided to extend to the President. Do you think that it is in order for the Chief Justice to call for a dialogue between him and the President with regards to what is actually taking place right now between the judiciary and the executive? Do you think that any such kind of dialogue would actually bear any fruit that at the end of the day would benefit the common man, because you need the government services at the end of the day? Allow me to stop this conversation at this particular moment, but please do not fail to subscribe to our channel here in case you're watching us for the first time, and please stay tuned to some of our programs that will be coming up next here. Till we have this conversation again, have yourself a lovely day. My name is Evans. Okay.